Now on to some of the more unusual and amusing legal stories of the week, presented by Nick Ross and Jane Walmsley, Out of Court.
Out of Court tonight goes into court, behind the scenes of America's newest TV courtroom drama. It's a real court, and it's a smash hit in the TV ratings coast to coast. You'll see why in just a moment.
And we'll be looking at the laws on rape, as some women lawyers call for a new definition. What's an assault and what's a rape?
And on a night when a big London borough faces a barrage of criticism from its ratepayers, we've legal comment from Michael Molyneux.
On how one group of angry ratepayers has found a way of taking their councillors to court.
But we start with that American courtroom drama. It's said to be educational, it's certainly entertaining, and we'll be asking in a moment if it might be on its way across the Atlantic. Civil litigation in Britain was never like this. From Los Angeles, Peter Bazalgette reports.
For over 100 years, the courthouses of California have been dispensing justice to its citizens. But now, for the first time, they're facing competition. From this television station, KTLA in Los Angeles.
They've decided that justice must be seen to be done every day on primetime television. This justice must be seen to be believed.
Here we go, coming to 4.
In 5, 4, 3, 2, 1.
Hop on 4 and kill.
All parties who will testify, will you raise your right hand to be sworn?
What you are about to witness is real. The participants are not actors. They are the actual people who have already either filed suit or been served a summons to appear in a California municipal court. Both parties in the suit have agreed to dismiss their court cases and have their dispute settled here in our forum, the People's Court.
You, Doug.
Hello, I'm Doug Llewellyn, and welcome to the People's Court.
All right, move in.
This is the case of the Too Slow ski boat. Now, the plaintiff and his family rented a house with a ski boat at Lake Arrowhead.
The People's Court is a real court, with real cases. But it's all happening in a television studio. In this case, a man is suing the owner of a boat he hired because the engine malfunctioned. But the owner claims that hairs from the man's dog caused the breakdown. Judge Joe Wapner calls for the vital witness.
Mr. Burrell, I don't know what you know about dogs, but you want to go over and see, tell me if you think that dog sheds a lot?
Well, yeah, any dog with long hair sheds.
Siegfried, come.
Very nice.
You could pet him and see.
In the end, the dog's side won. It hadn't molted negligently, and the owner of the boat was liable. In the People's Court, there's no appeal, but the verdict does come from a real judge, specially brought out of retirement. He's given a kitty of $800 for each case. The winner gets the lion's share, but both parties are guaranteed an appearance fee. The only thing left for the television company is to find the cases.
Well, there are 24, I think, or 26 municipal courts throughout the county of Los Angeles. These people have filed their cases already in court. And a research staff from the production staff of the show, they go out and they look up the cases, they call the people and ask them if they'd like to appear on our show. That's how we get them.
Why are you doing it?
I'm doing it for several reasons. One, it's a lot of fun. And two, and maybe even more important than the first reason, is I think it's very informative, very educational for the public. The name People's Court makes it's really is truly a People's Court, small claims, because that's the first, that and traffic are probably the two main courts that people ever get into in their lives. Very few people ever really see our courts or understand them. And if I can convey through this medium to people what general laws are, and so that people can live by the rule of law, I think the show will have accomplished something, and I will have.
Most people in this country think that only drama happens with big dramatic murder cases or incest and rape. Here, what everyone's saying is there is drama in small claims court cases. These people are as involved in their cases, even though they don't involve those kinds of crimes.
This is a new frontier. This is just they're out there with their bare selves hanging out, and this is what makes it so demanding a thing.
3, 2, 1.
And cue plaintiff.
The plaintiff. She says the defendant, her former landlord, made her life hellish and still owes her money. She's suing for $625.
And 3 in cue defendant.
This is Marty Bellin, the defendant. He claims the only mistake he made was allowing the plaintiff to rent the apartment in the first place. He's accused of not paying money owed to a tenant.
Hello, I'm Doug Llewellyn, and welcome to the People's Court. This is the case of the actress versus the Beverly Hills landlord. Now, the plaintiff, an actress, feels that her troubles began the day she signed the new apartment lease, because then she had to fend off the defendant's sexual advances. She feels her problems with the defendant, money problems, all stemmed from the fact that she turned him down, and she won't stand for it. The defendant says his firm policy is don't touch the tenants, therefore he owes her nothing. So what it comes down to, is this a case of harassment or simply an unreasonable tenant? Let's watch as Judge Wapner hears the testimony.
All rise, please.
Maybe seated.
The plaintiff, who calls herself an actress, is suing her former landlord for the cost of the parking fine she received when he didn't give her a car space, as promised in the lease. The landlord is counterclaiming for the cost of advertising the apartment when she left without proper notice. But at the bottom of the case lies her allegation that he made sexual advances. She turned him down, and he stole her bicycle.
What evidence do you have that the defendant stole your bike? That's what you're accusing him of.
Under normal circumstances, if I had not been subject to such enormous harassment from the landlord and from the manager, I would not have thought that that made any matter in this case. But since I have been harassed on so many occasions, enormously.
Well, how many occasions? You talked about, he said he wanted to be friendly, and you didn't want to, and then...
Well, I'll be very specific. After the first day that I moved in, after I signed the contract, he said, now suppose I come over some night and make myself comfortable.
That's a lie. All right, sir. Okay, I'll let you have your say. I just want to hear this.
And he said, we'll make some spaghetti or something like that, and you can put some coffee on and we'll get to know each other. And I said, no, absolutely not. I'm not interested in any sort of thing like that. And
you don't like spaghetti?
I don't like to be friends with someone that I have not initiated that relationship with.
All right, well, let's hear from the defendant.
Your Honor, first of all, it'd be very foolish as a businessman to fool around with any tenants.
Just say whether you did or you did. Did you tell her you wanted to be friendly and come
I
up
only
for
seen
spaghetti?
her one time when I rented the apartment, and the second time when she lied out on the grass of the front lawn in a bikini, sun-tanning herself with all the people coming around on Oakhurst Drive, of all places. That's the only time I ever saw her. How could I have done what she's saying?
Okay, all right.
Your Honor, I would like to interject that that is not true, that he has seen me on many occasions and has been at the door of my house on many, many occasions with letters and notes which I have in my possession. And you also see a letter in front of you from
Well, these letters have nothing to do with any kind of advances. They're all business-type letters.
I'm sure that nobody would ever write the things that he said in a letter.
Well, no, but you told me that you're making advances by writing notes and putting them under your door. Those letters don't say anything like that.
No, I said that he made advances to me, and when I refused him, that began a series of harassment.
Your Honor, she's not my type.
Okay. Did you ever tell her you'd pay for parking tickets for not getting this other
No, why
stuff?
should I pay for breaking the law?
Your
Of
Honor,
course not.
Your Honor, that is not true. He did say that.
Well, I realize you said he said it. He said he didn't.
These are minor things, but the main thing is, Your Honor, she had a one-year lease that she demanded when she moved in. If you look in the back of my lease, it even says there that she says she would not like to be raised. I put down on the lease, and rarely a landlord does this, no raise of rents, even though I'm entitled to a raise 8% in Beverly Hills each year. No raise of rents.
Mr. Bellin, after you did that, you laughed at me and said you do that to none of your tenants.
Will you shut up and let me finish?
Don't tell her to shut up. I'll control the proceedings, sir.
It just got me
Don't
very
interrupt.
riled up with all the lies that she's made.
I understand, sir, but you just tell me the story and let me control this, would you please? Why did you move out?
I was frightened.
Mr. Bellin said you had a year's lease.
I was frightened to death. There were nights that I could not sleep, that there were phone calls coming up. I was frightened.
Phone calls from who?
From Mr. Flaum, the manager who lived below me. He and his wife, and they would yell things up at me and bang with a board or something on the ceiling.
What is this gentleman seated there? Do you have something to add to this, sir?
Yes, I do,
All
Your
right,
Honor.
please.
My name is Michael Uten, and my vocation is an evangelist. And I have been over to Diana Jarrett's house several times. I know her as a woman of rare integrity and honesty. She just
Is that all you're going to tell me about her?
No,
character evidence
when
in a
I
civil
have been
lawsuit's
there,
not admissible,
no,
at least not
okay,
here.
when I have been there, it has been almost every time she has been just frustrated and almost in tears and was even crying. And because of the things that Mr. Bellamy had been saying or had been harassing
Did you hear
her.
what he said to her, sir?
No, I didn't.
How do you know that he caused her to cry and be upset?
She told him. I can only go by what
Mr. Bellin,
she
you
said.
be quiet, please, sir.
Okay. And then I was there one time when there was banging on the floor downstairs, and just because the clock was too loud or something, say, turn off that clock. Things like this. I mean, it was just unreasonable harassment that I would hear.
Thank you. Take a short recess. I'll come back and give you my decision.
We'll be back to hear the judge's decision in this case right after these messages.
During the commercial break, Judge Wapner withdraws into his specially constructed plywood chambers. There he's joined by KTLA's legal advisor. Together they decide between the actress and the landlord. Their verdict will be legally binding.
As we await Judge Wapner's return to the courtroom, allow me to remind you that all of the decisions that are rendered by the judge here on the People's Court are legal, they are binding, and final. This is real. This is not a reenactment.
All rise, please.
You may be seated. I'm going to tell you in advance that I'm going to give you my reasons for my ruling. And after I give you my reasons, I don't want any further argument from either one of you. And I'm going to tell you that in advance because there's been a little heat generated between the two of you. At any rate, with respect to the items that are listed up there, the first two items, the parking tickets and the stolen bike, the burden of proof is on the plaintiff to prove those items. She has shown that she was entitled to a parking space under the lease.
And she had it. I'm sorry.
That's what makes judges get ulcers and gray hairs. And I'm so young, I'm not entitled to that. She hasn't proven that one scintilla of evidence that either the defendant or the manager took that bike. It's almost an absurd allegation. As far as the deposit refund, the burden of proof's on the defendant to prove that he spent the money that he said he spent. I've shown it to my satisfaction, except for the advertising costs. I don't think you're entitled to advertising costs to rent a new apartment when you've waived notice as required. If you hadn't waived the notice, then you might be entitled to those advertising costs. So I'm adding $25.20 to the $35, and my judgment is for the plaintiff for $60.20.
May I say you something?
No, sir.
Hey, quiet, please. Stand by for the closing.
Are you satisfied the way the case has come out, to some degree?
I'm satisfied that I think Mr. Bellin has exhibited himself in front of people.
Well, we'll find out from him how he feels about it. Thank you for talking with us. Officer Burrell has some papers for you to sign in the back of the courtroom. All right? I must say, you look quite shocked at a lot of the things you were hearing in the courtroom.
Wouldn't you be if somebody says things like that to you all of a sudden?
How do you handle that?
You either shoot him, or you or you just sweat out if the judge believes it. If the judge is experienced, he believes it or he doesn't believe it. And obviously he's experienced. He didn't believe such a thing. But she can say what she wants about this sexual harassment and all. I only saw her once when I rented the apartment, and the second time when she's lying on the sidewalk grass, suntanning herself in a bikini. Now she's dressed like a pussycat, yeah, but in front of the judge. But this is not the innocent. Well, she's an actress. What more can I tell you? She's a pretty good one. I'm terrible. I'm the landlord, so I'm the guy with the black hat.
One other question would involve, how do you feel about the judge's handling of the case?
Very good.
He's human. That's all. He's human.
To put it nicely, She's a damn liar. But any girl can say anything she wants. Now, what are you supposed to do if you're on the opposite end? I ask all of you, what would you do?
Unfortunately, we're out of time. I'm Doug Llewellyn, thanking you for being with us and reminding you that when you think you're being ripped off or your rights are being offended, don't take the law into your own hands. Take them to court.
California really is a different world. Or is it? TV trials like that are bound to be looked on by many lawyers here as a silly piece of American whimsy. But what's to stop them happening here, Michael?
Well, not a lot. In fact, in English law, and in Scots law for that matter, there's nothing to stop two people with a private dispute from settling the matter by arbitration. And they can choose their own arbitrator. Suppose I sold my car to Nick Ross for £200.
No chance.
Well, he must have seen it. But anyway, suppose I did, and he now wants £50 off the price. There's nothing to stop us agreeing to appoint Jane Wormsley as our arbitrator. And the arbitration can take place anywhere. In my front room, or in this television studio with the cameras running. And provided that Jane is not grossly biased in her decision, we will have to abide by it. It's legally enforceable. So yes, we could have a TV court. And judging by the profits the show's generating in America, I suspect that we will have one. Now, the legal establishment will probably throw a spectacular tantrum at the idea, but it could make the law seem a lot more understandable to a lot more people.
Now, you may have noticed in the case we watched in the People's Court that the actress's complaint of sexual harassment was rejected by the judge. And that brings us to our next subject. The women's movement has long complained that because men dominate the law and the courts and the police, it's a frightening and often impossible task for a woman to get a conviction against a man for any form of sexual assault. This is a satirical look at the problem from the BBC show Revolting Women.
Look, I've been robbed! £20!
Robbed, you say? That's a very serious accusation, Mr. Phillips. Are you sure you were robbed? Or did you give it away? Eh?
What is that for?
People do funny things in the heat of the moment, and sometimes they change their minds afterwards. Didn't you want it to happen at first?
What to happen?
Getting yourself robbed. Didn't you enjoy it just a little?
Enjoy it?
A man your age, Mr. Phillips. Haven't you ever had fantasies of being robbed?
No.
First time, eh? Big boy like you. Were you wearing those clothes?
Yeah, what's left of them, yeah.
Casual, really, aren't they? And where was this money?
In my wallet, in my pocket, here.
Top pocket, eh? Big, fat wallet. Bulging out a bit, would you say? And two nice, crisp tenors poking out the top, just a teeny bit?
Well, yeah, maybe, but...
Well, there you are, then. You were asking for it.
Well, that's how some women say rape victims are really received. This week, a group of feminist lawyers have come out with new proposals to amend the law on rape. They're submitting them in response to this consultative document from the Criminal Law Revision Committee. They're calling for a new definition of rape, and they want rape to be a criminal offence, even within marriage. One of the authors of the new report is a solicitor, Elaine Ginsberg. You say you want a new definition. Rape is rape, isn't it?
No, we don't agree. We think the present very narrow definition of rape isn't good enough to reflect women's experience of sexual violence against them. For example, because the present definition is confined to forcible sexual intercourse, acts of violence against women such as forcible penetration by a fist or a bottle or forcible oral penetration are not covered by the present law of rape. They're classed as indecent assault. We think they should be classed as rape. Secondly, we think there's a great problem in the present law in that if a woman fails to resist or fails to have evidence that she's resisted in the form of bruises, then quite often that can stand as evidence that she's consented to the crime.
Despite the fact that the police advise women not to resist in that sort of situation.
So that women are in a double bind.
Yet I'm surprised, I must say, at the extent to which you use quite harsh words about the Criminal Law Revision Committee. It seems to me that you agree with them on so many things, yet you call them condescending.
Yes, well, their attitude throughout the report is one that's very widely held, which is basically that women who behave as independent people, for example, a woman who invites a man home for coffee or a woman who's hitchhiking on her own, is asking to be raped. We find that totally unacceptable. It seems to be implying that any woman who takes part in any unaccompanied situation with a man is exposing herself to sexual violence and has to be blamed for it.
I don't think that's what they would think they're saying. But what they do think they're saying, and what I would have thought you agree with them about, is this new change, and perhaps the most important of all, which is criminalising rape within marriage. Now, you agree with them on that, don't you?
Yes, we agree that rape within marriage should be a crime, but we don't agree with the proviso that they've put on their proposal, which is that charge of rape within marriage will only be able to be brought with the consent of the Director of Public Prosecutions.
You don't feel they should have to say, please, sir, we want to bring a case?
Absolutely not. Already the police have a very wide discretion, and as we've seen from the sketch, they don't always exercise it properly.
Very briefly, though, how do you get around the problem of malicious complaints? I mean, one of the problems of rape is that it's a crime which is often very difficult to corroborate.
Certainly, but there's no evidence that there are any more malicious complaints of sexual assault than of any other kind of crime. It seems to me that there's always a problem if the only witness to a crime is in fact the victim, and that applies to other crimes, and particularly crimes of violence. It seems to me that one answer to this problem, if it is a problem, is to adopt the approach that New York City adopted. They introduced a special squad of specially trained women police officers to investigate complaints of sexual violence against women, and they found that the number of unfounded allegations was exactly the same as for other crimes of violence.
Ellen Ginsberg, thank you very much.
Thank you.
Today, all national newspapers have been carrying full-page ads asking, "What's Whitehall up to behind your back?" It's the start of a campaign by some local councils to keep local government local. They're accusing central government, and Michael Heseltine in particular, of laying down the law to them on what the rates should be. But today, Michael Heseltine was cheered on at the Tory party conference for turning Whitehall's guns on local authorities like these, who've increased their spending most in the last 3 months. These are the top 10 on his list of targets. And in Scotland, there's a powerful battle underway between Lothian Regional Council and George Younger, the Secretary of State.
But in some places, the councils are under attack not just from above, but from below, from we, the ratepayers. Tonight, the councillors of the London Borough of Camden are locked in a heated public meeting with hundreds of their ratepayers who are angry that Camden is now the highest-rated borough in Britain. In fact, they're so angry that they're taking the law into their own hands. Now, normally, if there's any suggestion that councillors are spending money recklessly, there's an independent official there to intervene, the district auditor. But in Camden's case, they've bypassed the district auditor and gone straight for the jugular. The Camden Ratepayers Association are taking their councillors to court, and in doing so, they're making legal history.
It's the first time individual councillors have been sued by individual ratepayers for alleged breach of duty, which in this case means misuse of funds. The idea is to establish the principle of personal accountability in local government. What that means is that if the ratepayers win, Camden's 30 Labour councillors will have to pay damages out of their own pockets. The estimated losses are heavy enough to make most of them bankrupt. No wonder tempers flare at council meetings.
We have no right to spend ratepayers' money on that point.
They are ratepayers
We have no
themselves,
money.
you fool.
We have
Who
no
do you think,
ratepayers' money to waste.
they live in houses? Of course they live in houses locally. They're ratepayers.
They're all
We're talking
true.
about putting ratepayers on the dole queue, you stupid man.
Leading light of the Camden Ratepayers Association is Diana Yack, who also happens to be a solicitor, a lecturer in law at London University, and one of the litigants in the case.
We're bringing this action because of the devastating effect that rates are having on ordinary people in the borough of Camden. And we simply want to say to the councillors, enough is enough. This is the first time that something like this has been put forward by a Ratepayers Association, and we want to show them that we are serious about our intentions and that they can't be allowed to get away with it for any longer.
But aren't these 30 councillors simply doing what they were elected to do?
Yes, they were elected to be our representatives, but they were not elected to spend ratepayers' money in the way which they're doing, in other words, misusing our funds.
To support that claim, the ratepayers cite the case of the Branch Hill estate. These 42 council houses are the most expensive in Britain, built at a cost of £109,000 each. Another example, Camden's decision to hire 100 extra construction workers when building programs were being cut back. But why sue when you could call in the district auditor?
We've referred several things to the district auditor, but he takes far too long to act, and also he acts after the event, after the money has already been spent, and it means that there is really little that a ratepayer can do to stop something happening right at the beginning, and this is one of our major concerns.
A few days ago at a London hotel, the Camden Ratepayers organised a conference on the future of local government. Surprisingly, the principal guest speaker was Ken Livingstone, Labour leader of the GLC, and coincidentally, one of the Camden councillors these people are suing. But he showed no sign of fear in the enemy camp.
Well, I think it's important to come because really we should be on the same side. They're opposed to higher rates and so are we. We actually would like to be able to bring the rates down because they're hitting Londoners now. The question is, they've tended to see the enemy as the councils, whereas we see it as the government who's held back about £400 million of our grants.
But they are actually suing you for misuse of public funds. Now, how do you react to that?
Well, I think people have to be accountable, and if they don't like our policies, the main thing to do is actually to stand against us and get rid of us at the next election.
We felt that accountability, which is sorely lacking in local government at the present time, needs to be strengthened. This was one way of doing it, and by holding councillors individually responsible for their actions, we are certainly showing ratepayers all over the country that there's another route or another channel which they can pursue in law.
Livingstone shared a platform with the man he ousted as leader of the Greater London Council, Sir Horace Cutler. Sir Horace was sustained by the thought that if the ratepayers win their case, his arch-rival will be personally liable for debts which may top £200,000. There's no doubt he's enjoying Livingstone's predicament, and he's not much worried about dangerous legal precedents.
If you take on a public office, you should take on the responsibilities of that office. And one of the responsibilities is like a trustee of funds. If you're in charge of public funds, you have to be totally accountable. You have to use them properly. If you use them in any other way, you're likely to get a lawsuit on your hands, and so you should.
Are you going to enjoy the spectacle of the likes of Ken Livingstone being held personally accountable for Camden's debts?
It has a certain savoury aspect to it, yes.
The main people to benefit out of this are going to be the lawyers, not either the people bringing the cases or the councillors. The courts and the people in them will make a bomb out of it. At the end of the day, local government will go down the pan and people will still have massive rates.
Well, that may be so, but it's not exaggerating to say that this case could be one of the most important brought before the courts this decade. Why, Mike?
Well, it's important because if the idea catches on, it could undermine local democracy. Now, there is no shortage of ways of keeping a check on local councils. If you don't like their policies, then you can vote them out of office. And there's an election in Camden next May. If you think they're overspending, then you can complain to the district auditor, and he does have powers. Remember Clay Cross, where the councillors had defied an Act of Parliament and refused to raise their council rents. Well, the district auditor there imposed a surcharge of £6,000 on 11 councillors to be paid out of their own pockets. But you can see the danger of going to court from a much earlier case. In the 1920s, the London Borough of Poplar defied their district auditor. They decided that as model employers of labour, they'd pay their lowest grades of workers, whether they were men or women, a minimum wage of £4 a week. Now, the district auditor stepped in, it went to court, and it finished up in the House of Lords. And there, giving judgment against the councillors, Lord Atkinson said they'd been
guided by some eccentric principles of socialist philanthropy, or by a feminist ambition to secure the equality of the sexes in the matter of wages.
And that's the problem. If Ken Livingstone and the other Camden councillors come up before a modern-day Lord Atkinson, they too will presumably be judged eccentric, and the result's a foregone conclusion. In other words, a case like this could turn out to be more a test of the impartiality of the judges than a test of the behaviour of the councillors. So it's somewhat surprising that the Camden action was allowed to go ahead. In England, for you to be able to sue your local councillors like this, you need the backing of the Attorney General. You can't do it without his blessing. When I asked why the Attorney General had agreed to this particular action, the very first of its kind, I was told that's the sort of question we never answer. Well, perhaps they should answer, because this case is likely to put the judges in an invidious position. It threatens to involve them in local politics, and politics are for the ballot box, not the courts.
Just time to tell you about the barrister and the beam. when Mr. Norman Rudd, a 6'2.5" tall barrister, walked into an old inn in Yorkshire, he banged his head on a beam above the door and was off work for 9 weeks. It says something about the thick-headedness of the British legal profession, perhaps, that having banged his head, the chief injury seems to have been to his ankle. Anyway, dismissing his claim for damages today, the judge observed that when a 20th century lawyer walks into a 17th century pub, he should watch where he's going.
And watch us out of court next week. Good night.